solemnly swear to tell the whole truth and nothing but the truth and nothing but the truth. Please be seated.
One thing first, that you instructed me to inform the jury. Yesterday, there was an issue with an exhibit. And we said we were going to submit an exhibit 99 to clear that up. That exhibit is actually included already as part of exhibit 70. And you'll find it in there. It's already part of 70. And
It's in the red book.
Pardon?
In the red.
70 in the red book.
In the red book.
So, if you're looking for 99, just report back to 70 in the red book. At this time, I want to move for introduction of exhibits 33 through 43 inclusive in the red book.
Any objections?
No objection, Your Honor.
All right. Exhibits 33 to 43 are admitted in the red book. You may proceed, Counsel.
Thank you, Your Honor.
Just as a housekeeping matter, I think we're going to admit all of the 1 through 8 in the White Binder City Center as well.
This morning? Oh, all right. Okay.
Ma'am, I need you to start out by stating your name.
Joanne T. Steiger.
And Ms. Steiger, are you married?
Yes, I am. At this time.
Do you have any children?
Yes, I do.
Are you presently employed?
Yes, I am.
By whom?
The Goldman Sachs 10,000 Small Businesses Initiative in Chicago.
Tell the jury what that is.
That is a job entrepreneurial training program that is funded by Goldman Sachs through the city colleges of Chicago. And what we do is we train entrepreneurs to grow and hire people from their local communities to grow their businesses.
Do you have any other vocations beyond that?
Yes, I'm actually an adjunct professor at Kendall College, and I teach a business negotiations and conflict management class.
Thank you. Could you briefly describe for the jury your experience with real estate or in the real estate world?
I was a certified general real estate appraiser for about 12 years. I'm certified in the state of Indiana and Illinois. During that time, I specialized in commercial and industrial properties, the valuation, and I was also trained through the Appraisal Institute, taking all the classes. Excuse me, my throat's a little dry today.
Do you need some water?
No, I just
Okay.
allergies. Taking all the classes that were necessary for the MAI designation.
And could you tell the jury, at some point were you employed by Fifth Third Bank?
Yes, I was. I began my employment in April of 2005.
And when you joined them in April of 2005, in what capacity did you join?
I was the Vice President of Commercial Real Estate, lending, and a relationship manager. Those positions were kind of synchronous.
And how long did you work for the bank?
I worked there for 2 years.
Did your position stay the same during that 2-year period?
Yes, it did.
And specifically, I want to refer you to the time period in the spring of 2006. Do you have a recollection of working for the bank and what you were doing during that time period?
Yes.
And specifically in regards to the city center loan, are you familiar with that?
Yes.
Tell the jury how you became involved in, or your participation in that process or that loan.
I first saw the file when the prior relationship manager left the bank for another position. I was assigned the file, and that was the first that I saw of it.
Then, once you were assigned to the file, how did you become acquainted with it?
The normal process that we used in the bank was that we would review all the documentation that was in the file, and we would generally seek to meet the principals on the loan. So it was reading all of the documentation that was contained in the loan and having a meeting with the person.
And how was it that this loan was assigned to you? Do you remember?
No, I don't recall. That was something that was the choice of my manager.
Do you recall who the relationship manager was that was assigned to this loan before you?
Yes,
Who was that?
Brian Speck.
Did you ever have any discussions with Brian about the loan or his participants?
No,
Was one of the documents that you reviewed during the process that you previously described the real estate and construction loan agreement?
yes,
Now, that's already been admitted into evidence, and there are a few provisions in that agreement that I want to ask you about. So you don't have to open up our books, although you may if you want. I need to do this so that everyone can see. Can you see this, Ms. Steiger?
yes,
Okay. Do you recognize this portion of the loan agreement?
yes, I did.
After you read Article 1.3E, did you do anything in your final review to determine whether or not it had been complied with?
Yes,
What did you do?
I looked for the leases that supported the construction that was taking place.
And specifically in relation to this part of the agreement, what were you looking for? Why did you want to look at the leases?
The value of the real estate property depended on the leases being in place. And so the project would stay on track if the leases were legitimate and in place.
And how would you go about determining whether or not the leases that you were reviewing met the requirements of the lending provisions?
They were contracts, and so the contract had to have a date, have a specific term, have a specific amount. The amount had to be paid on a regular basis. It had to be executed and signed by both the owner of the property or the owner's representative and by the person that was going to be leasing the property or the entity. And generally that had to be notarized and there was some type of a payment involved.
What about square footage? Did that enter into your analysis at all? The square footage that was being leased?
Yes.
Okay. In what respect? As it applies to the lending provisions.
The square footage would determine the 50% or the 75%. So if a building, for example, is 10,000 square feet, we would be looking for 5,000 square feet of lease-up space.
And so we're clear when you say 5,000 square feet of lease-up space, how does that apply to what the loan agreement required? That is, the percentage requirements.
Well, we would be looking for a certain percentage of the building to be leased up relative to the square feet.
And then how did the 75% requirement come into play?
The 75% requirement came into play when a new building was to be constructed. So what we would do is be looking for what had happened to the prior buildings and then be looking for lease-up requirements on any new building.
In your review of the construction, real estate construction loan agreement, did you familiarize yourself with the definitions that were set forth in that document?
Yes.
Did you review the office lease provision?
Yes.
And you see it there, and you can find that on page 8 of the loan agreement, is that correct?
I don't recall exactly what page, but
In the black book, Exhibit 4, you'll go to page 8 with me. And do you see the definition of office lease?
Yes, I do.
And is it set out verbatim, just as we have here on the easel?
Yes.
Do you also see the definition for pre-leased in there?
Yes.
And is it set forth verbatim, as we have here on the easel?
Yes.
And then finally, do you see retail lease set forth on that page?
Yes.
And is it also verbatim what we have here?
Yes.
How did these definitions enter into your analysis of the loan file when you did your review?
The loan was approved, subject to the lease-up being with office and retail space only. So those were the only types of allowable leases that were able to be funded through the loan. So if another type of lease was brought in, we would have to look at that independently because that was not included in the actual agreement.
Go back to page 6 for a minute of Exhibit 4 and look at Article 8.4. Have you read that to yourself?
Yes.
Do you remember that being part of the agreement?
Yes, I do.
And do you have any knowledge of that specific provision ever being modified at any time while you were administering the loan?
No.
Do you have any recollection of that provision ever being deleted while you were administering the loan?
No.
Do you even recall at any time during the loan anyone requesting a modification or revision of that provision?
No.
I want to refer you to page 11, Article 13.2. Is it entitled Modification and Waiver?
Yes.
And is it set forth verbatim, just as it is in the document in front of you, Exhibit 4?
Yes.
Did at any time during the time that you administered the loan receive a request from City Center, Richard Plank, or anyone else requesting a modification of this provision?
No.
At any time during the time that you were administering the loan, did you receive a request from Richard Plank or City Center asking that that provision be deleted?
No.
After you completed your review, contract, and the other loan documents, what did you do next?
I spoke to my manager and sought to make an appointment to meet the principals of the loan.
Did any issues arise after your review of the documentation and the loan agreement?
Yes.
Do you recall as you sit here today what those issues were?
Yes.
You know, while I'm thinking about it, I want to ask you a question. We've met before today, true?
Yes.
And we actually discussed the questions that I was going to ask you today, didn't we?
Yes.
And we did that so we could speed things along today,
Yes.
correct? What issues do you recall arising after your review? Off the top of your head.
The leases that were required for the vertical construction to continue were not in the file. The financial statements that were required by the covenants of loan were not in the file, nor were updated. The subcontractor agreements and contracts were not in the file. And off the top of my head, those were the original ones.
And then, as a result, you met with your manager, is that true?
Yes.
And then what did you do?
I made a phone call to Mr. Plank and just asked him if we would be able to get those documents.
And what did he tell you?
He said yes, he would provide all of those.
And then did you go and meet with him?
Yes.
Do you remember approximately when this was?
I don't remember exactly, but it was probably within a short time after the review of the loan. So.
Do you remember when it was that you commenced your review of the loan file?
It was shortly after Brian left the bank.
Now, tell us about that first meeting. You had a meeting, correct?
Yes.
And then tell us about that meeting. What transpired?
We asked for documents. It was just an introductory. We had no cause for concern at that time. We thought that documents were missing from the file and that we could request them and we would receive them, and we just wanted to establish a relationship since I was the new relationship manager.
Were you provided any documents at that meeting? Do you recall?
I don't recall being provided documents at that meeting.
Let me refer you to what has been introduced into evidence in the red book as Exhibit 51. Do you have that in front of you, ma'am?
I do.
All right. Now, Exhibit 51, did you author this?
Yes, I did.
And what was the purpose for you sending this email?
The purpose of the email was to ascertain if they had the documentation that was required by the loan compliance.
And can you tell the date that this email was sent?
Yes, it was May 19, 2006.
Did you identify any issues in the email that were concerning you?
Yes.
Well, were they concerning you? I should ask you that first.
I think they were at this point more of a documentation issue.
Now, item number 1, what was your, what were you trying to document there?
There was some confusion as to the numbering of the buildings, and the construction advances didn't appear to match up with the amount of progress that was done on the construction of the actual site. So we wanted to check to see if the numbers, if the buildings had been renumbered.
And was that issue resolved to your knowledge?
There was still quite a bit of confusion about it, even as we move forward in the relationship.
And as we, did you eventually resolve that issue?
I think it was resolved.
And this has previously been admitted into evidence, and you recognize this as one of the buildings that was under construction.
Yes, I
I'm
do.
referring to Exhibit 100, the bolded building in the lower right-hand corner, correct?
Yes.
And you recognize the building, the elongated building in the middle as the second building.
I do.
And how, when we refer to this building as building number 2, correct?
Yes.
The one on the lower right, this would be the southeast corner. And the one on the west side of Exhibit 100 is building 6, correct?
Correct.
All right. Just so we're all on the same page. What is the second paragraph referring to?
The equity contribution that was required prior to each building being started.
Now, what do you mean by equity contribution?
For each real estate project that is funded by the bank, a portion of that is paid through the owner of the property or the person that's the developer who could still be the owner. So in a real estate transaction, it's traditional that the owner's funds go in first to pay the initial bills, and then the bank follows up afterward with the remainder of the funding.
Did you have any documentation in the file that you could see that complied with paragraph number 2 of Exhibit 51?
No.
What were you seeking in paragraph 3 of your email?
I was trying to ascertain if that building had been 75% leased up through the leases that were required to start a new building. So, as per what we were discussing before, when a new building was started, the building that was already under construction had to have a certain level of lease up for the new construction to start. And so that's what I was looking for.
And specifically, what provision of the loan agreement?
That would be the, is it D? No.
There's
E and F, I'm
and
sorry.
G.
My vanity and content.
Do you like the glasses? All right, and then paragraph 4 of Exhibit 51, what were you seeking there?
It was pretty much the same thing, looking at the 75% lease up because another building had been started. There were 2 foundations that were put in, which were vertical construction to start. So every time that a vertical construction was begun, that triggered another need for a $210,000 equity contribution.
And did you have anything in your file that would have at least alleviated your concern in regards to that provision? Or were you seeking that also?
I was seeking that information also.
Paragraph 5, what do you, of Exhibit 51, what are you seeking there?
I was looking for the 50% of the leases that were the lease up that was required for a building to actually be approved to be funded for construction.
I note that you used the term rent rolls in paragraph 3, paragraph 4, and paragraph 5. Explain to the jury what rent rolls are.
A rent roll is simply a listing of the tenants that comprise the economic stream of the building. And so you would have a list of who the tenant was. You'd have the date that the lease started, the date that the lease stopped, the date that any other payments were due. For example, sometimes taxes and insurance would be due. So it would give you a very comprehensive listing of all the activity of the building so that you could judge when your income was coming in.
And why is that important, to judge when the income is coming in?
Because there was debt on the building and debt service had to be made once the building was stabilized. And also, this is not a residential property, it was a commercial property, and so the value of the property is derived from its economic attributes.
You used a couple terms there. One was debt service. Is that just a fancy term for payments of principal and interest?
Yes.
The other term you used was stabilize. What does that mean?
Stabilized means that you want to get the building to the point where there's not a lot of leasing activity, where the tenants are in place, where you can actually count on the revenue that's coming in so you can make the bills on a regular basis.
Referring you back to paragraph 4 of Exhibit 51, you used the term, at the end you say, or was it pre-sold, referring to building number 6. Why did you add that?
If I recall, there was a provision in one of the credit memos that referred to a potential sale on one of the units.
And that's the building 6 on the west end of Exhibit 100 that we previously looked at?
Yes.
You recall from your initial review what that was to be pre-sold for, the use that it was going to be sold for?
I believe it was a restaurant.
And then finally, paragraph 6 of your email, Exhibit 51. What are you seeking there? I
was asking for verification that the materials that were purchased for future buildings that we were not currently funding, trying to find out where it was and how much was there and why the cost was being currently requested in a draw for buildings that we weren't currently funding.
I want you next to, let me check and see if it's been admitted. If you would turn to Exhibit 52, not the jury yet. Do you recognize that document?
Yes.
And did you author that document?
Yes.
Move for the introduction of Exhibit 52.
No objection.
Exhibit 52 is admitted.
Why did you send Exhibit 52?
If I recall, we had a meeting with the owners of the property, and I was able to ask them for the documents that we had requested. Apparently, from looking at this, it said that they had submitted them, and I had the files checked, both in Maryville and in Chicago, and we didn't have the documentation. So I was following up with them again to let them know that we still didn't have the documentation in file and was requesting it again.
There's a reference there in the second line of the text where it says no leases or LOIs. What are LOIs?
An LOI is a letter of intent to lease or to purchase a property, and it's non-binding. If I referenced that, it could have been because that's what they gave to me, an LOI.
Were LOIs acceptable to the bank to meet leasing requirements?
No,
Why?
they're non-binding. So that means that you can't count on the person that signed that LOI to actually sign a contract. It's just an intent, not a contract.
Do you recall, after your May 16th, that is the Exhibit 51 email, how many times you met with City Center's representatives while you were the relationship manager?
I don't recall specifically, but several times, I'm sure.
And do you recall generally what the purpose of those meetings were?
Yes.
And what were the purposes of those meetings?
The purpose of each meeting was to continue to follow up and obtain the missing documentation that was requested from the initial email that was sent.
Let me have you and you only turn to Exhibit 55. Did you author that document?
Yes, I did.
Move the introduction of Exhibit 55.
No objection.
55 is admitted.
First of all, what is the date of this email?
June 13, 2006,
And who is it directed to?
to Richard Plank.
And what is the purpose of this email? Why was it sent?
Prior to each draw request or funding for the loan, we had an inspecting engineer go out and verify that the work that was completed was in alignment with what the budget and the draw request was for. And apparently the inspecting engineers had some issues that they wanted to discuss. And so we invited Mr. Plank in to the office so that we can all talk about them together.
And did that subsequently happen, do you recall?
Yes.
And were those issues cleared up at that time, the best that you can recall today?
To some degree.
during any of your meetings with the city center personnel, up to this point, June 13th, 2006, did any individual from city center ever deny or disagree with the leasing requirements?
No.
Did anyone from city center ever tell you that they didn't have to provide any more leases?
No.
Did they ever tell you that you didn't have to provide any non-binding, or that they didn't have to provide to you any more non-binding LOIs?
No.
What about binding LOIs? Did they tell you they didn't need to provide those?
No.
At any point up to June the 13th of 2006, did anyone from City Center or its representatives ever disagree with the equity infusion requirement?
No.
What did City Center, after this May 30th email, that was Exhibit 52, I believe, what were you told as Fifth Third's representative as to what they would do to comply with your requests?
After the May 30th?
Yeah, what did City Center say?
That they would make sure that the loan was brought into compliance by supplying all the documents that were required and requested.
Did they eventually provide you with any documents in that respect?
Several documents were provided.
To your knowledge, did the bank, Fifth Third Bank, ever change its position on the lease requirements under the construction loan agreement?
No.
Did Fifth Third Bank, to your knowledge, ever change its position on the equity infusion requirements under the loan agreement?
No.
And when I say loan agreement, I'm referring to Exhibit 4, correct?
Yes.
Did Richard Plank ever claim that the equity injections were met?
No.
Did, let me refer you to what has already been admitted as to evidence as Exhibit 67A, just for reference. Let me ask you a question. The leases that you were provided, do you remember, were they partial leases or full leases?
Partial.
And do you recall receiving 67A? It should be page stamp 1224 in the lower right-hand corner.
All right. Yes. All right, yes.
And what's the date of that?
June 1st, 2006.
So this is dated roughly 2 days after your May 30th email requesting leasing activity, correct?
Yes.
And do you recall receiving this document?
I don't recall, but it's been a while.
Was this an acceptable lease?
It was a partial document, so it was not an acceptable lease in that we couldn't determine what all the terms were. Additionally, the tenant was not an arm's length tenant.
What do you mean by arm's length?
An arm's length tenant is someone that's unrelated to the party that's leasing. So if you have your son or your daughter lease an apartment from you, that would not be considered an arm's length lease.
Why would that be prohibited? What's wrong with that?
Because there's a relationship that might be implied that would cause you to change the terms of the lease without really any economic reason.
Turn to 67B. You provided with that.
Yes.
What is 67B?
This is a partial lease.
Between whom?
City Center and Richard M. Plank.
Was that lease acceptable?
No,
Why?
it was not an arm's length lease, and it was a partial document.
Were you able to determine whether these were commercial leases or residential leases? Do you recall the time?
No. I don't recall.
For instance, on page
In looking at them now, they're set up to be commercial leases.
let me refer you back to 67A. Go to base stamp page 1228. 1228. 67A. About halfway down, Article 1.04.
Yes.
That's address for notice. Do you see that?
Yes, I do.
What is that address?
5616 Novara Place, Sarasota, Florida.
Are you aware of any Richard Plank living in Sarasota, Florida?
No.
Turn to the following page, Article 1.13. Do you see that?
Yes.
What's it read?
Use of the premises residence.
Is that acceptable?
No.
Why?
The covenants of the loan stated specifically that the building was an office and retail structure.
What would be the effect of utilizing the premises for residential use as it related to the bank's funding of the loan? Tell the jury.
The funding of the loan was for the office and retail use. When the loan request was received by the bank, the valuation of the property was contingent upon the use of the property as a retail and an office building. The rental levels for a retail and an office building are significantly different than that would be determined by an apartment building or something to that nature. So it would significantly alter the agreement and change the context of the entire structure.
So would the bank say, sorry, you can't use it for that purpose?
No.
What would it do?
The only thing that we could do is the funding of the loan. We approved the funding for a specific reason, which was office and retail construction. If Mr. Plank or whoever decided to change it to residential use, that was his prerogative, but that didn't guarantee that we would support that in terms of funding.
Turn to me if you would, to Exhibit 68. Are you there? Was this presented to you, to the best that you can recall?
Yes.
Was this acceptable to the bank for purposes of the leasing requirement?
No.
Why?
It's a partial lease and it's a non-arm's length transaction.
Turn to page stamp page 1208 of Exhibit 68, Article 1.13. Did you see that?
Yes.
Read that.
Use of the premises.
Does it have a use?
No, there's no use.
Finally, turn with me, if you will, to Exhibit 69. Are you there?
Yes, I am.
Was this lease presented to the bank?
Yes.
Incidentally, the prior 3 leases and this lease are all even date, is that correct?
Yes.
What are they dated?
June 1st.
Again, 2 days after your May 30th email, correct?
Correct.
And turn to page 2 of the lease. Use of premises, Article 1.13. Did you read that?
Use of the premises residence.
Was that acceptable to the bank
No.
for the same reason as the others?
Yes.
Now, do me a favor and turn to the rider in the back. Rider number 4, it's page 3, it's roughly 4 pages from the end of the document. Are you there?
Yes, I am.
This is still part of the same lease, correct?
Yes.
What's it labeled at the top in the center?
Prohibited uses.
Go down to paragraph 12. What is the prohibited use in paragraph 12?
It states any residential use, including but not limited to living quarters, sleeping apartments, or lodging rooms on lower level suites.
Did you find any internal inconsistency in this document?
Yes.
On your review? And what was that internal inconsistency?
The lease was for residential use and for residential rental, but at the same time, the rider prohibited the reason for the lease.
What did your initial review of the loan documents reveal to you as to the proposed and permitted use of these premises for funding purposes?
It was clearly stated in the documents that the buildings were to be constructed for office and retail use.
Did you ever find out that there was a different use being utilized on the premises of City Center?
Yes,
How did you find that out?
by inspecting the premises.
And who was with you?
Richard Plank and Dan Yamtich.
Describe generally what happened or how you made that discovery.
We had a site visit for the property, and Mr. Plank met us at the property. We asked to see what type of improvements had been made, and he took us up to the second floor after we had looked at several of the retail spots that were on the first level, and he showed us his apartment that he was living in. It was a fully furnished living quarters apartment, and that was the first that we knew that there was residential use in the property.
Did you respond to him at that point about that use?
I was surprised and asked when the use was changed.
What were you told?
He said that he now had planned to condo the second floor units, and he was having condominium declarations drawn up by his attorney.
hold that thought about condos, because before we get into that, I want to ask you about what has been introduced into evidence as Exhibit 66. Are you there?
Yep.
Is this a document that you've seen before?
Yes, it is.
And what's it dated?
May 1st, 2006.
And who is the tenant identified on this document?
Johanna Boderman.
At the time that you reviewed this document, did you know in fact who Johanna Boderman was?
Not specifically.
Generally, did you have an idea?
I didn't know who Joanna Boderman was, but there was something familiar about the name to me.
Did you subsequently find out who in fact Johanna Boderman was?
Yes.
And who was she?
Richard Plank's wife.
Was there anything about this lease that would have been unacceptable to Fifth Third Bank?
It was a non-arm's length transaction, and we did not get the entire lease.
Had you had the entire lease, would it have been acceptable?
No, it was a non-arm's length transaction. And also it was for a restaurant.
Why was that an issue?
The restaurant was specifically prohibited by the covenants of the loan, the restaurant usage.
What about Z Grill? They were there, weren't they?
Yes.
Why was that acceptable?
They comprised a very small percentage of the leasable area within the building, and that was generally considered to be within the tolerance of a typical vacancy.
Explain that a little bit to the jury when you say the tolerance of a typical vacancy. That sounds like a term of art, maybe.
It just means that they were a very small percentage of the total square footage of the complex. And so that was still a risk in having a restaurant there, but because it was such a small risk, it would have been likely that we could have approved something like that.
In reviewing or analyzing a development like this for retail and office, are there assumptions made as to vacancies?
Yes.
What sort of assumptions?
There are assumptions based on what the surrounding market supports. So, for example, in this, I don't remember what the assumptions were made here, but it would depend on what other competing centers had in terms of vacancy as an average. So if it was 10%, we would assume that there would be 10% of the building at any one time that was available to be leased.
And then what about restaurants in general? Is there any concern with restaurants in general?
Yes, restaurants in general, when they're starting up, have a very, very high failure rate. It's close to 9 out of 10 in the first year. So that's the concern with lending on a new restaurant, is that there's a very high risk involved with that revenue stream. And that's why they're generally prohibited by banks.
Do you know if Sea Grill is there today?
I don't.
I want to go back now to the point, you talked about condos on the property before.
Yes.
Explain to the jury what condos are and how they are different from apartments or residential use.
A condominium can be commercial or residential, but it generally means that the person that's purchasing the space is buying the interior of the unit plus access to the hallways and entrance areas. Because you have an arrangement where you have a lot of people owning different percentages of a property, it's very important to have a set of rules and guidelines by which these sales and resales and leasing transactions are governed. And those are called the condominium declarations.
And did you ask for a copy of the condominium declarations from Mr. Plank?
Yes, I did.
Did you receive a copy of the condominium declarations from Mr. Plank?
No.
Why did you request them?
Because he told us that he had planned to provide, to sell the units as condominiums.
Would that have been acceptable, Fifth Third Bank?
I think it was something that we were willing to consider,
Why?
because really what we were trying to do at that point was to stabilize the property. There was construction going on, we had subcontractors that needed to be paid, and it was very important to maintain the economic integrity of the project.
Did you ever have any discussions with Mr. Plank wherein you conveyed the thought that residential use was non-compliant with the loan agreement, Exhibit 4?
Yes.
Do you approximately recall the time frame as we see here today?
It was probably around the same time that we inspected the property and found that there were apartments.
And then, did you tell him he had to vacate?
No.
Why not?
It's his right to do what he wants with that property. It just couldn't be funded by the bank.
Did he ever make a request as a result of those conversations, in writing, requesting the loan modification, the terms of the loan agreement?
No.
Did he ever in writing make a request to delete that residential use requirement from the loan agreement?
No.
Do you recall funding draws, both in approving funding of draws in May and then subsequently in July also?
I accepted construction statements for proposed funding, yes, and they were subsequently funded.
Why were they funded? If you thought these issues were out there.
The bank felt that it was in the best interest of the property to stabilize the project and to pay the subcontractors that were involved. They had already done the work. We did not want to incur more liens on the property, and it was very important for us to be able to stabilize.
At any time, to your knowledge, did Fifth Third Bank ever notify City Center that it had no obligation to comply with the loan agreement?
No.
When did your involvement with this particular loan cease? Do you recall?
Probably sometime in the fall of that year. I'm not quite sure of the time.
At any time, while you were the acting relationship manager, as it pertained to this file, did you ever receive condominium documents from Mr. Klein?
No.
Or City Center, did you?
No.
In regards to Building 6, that is the west building, shown on Exhibit 100, did you ever receive a purchase agreement for that property? Do you recall?
I don't recall.
Do you recall ever receiving a binding letter of intent for that property?
No.
Now, when you were having these discussions with City Center about the required equity infusions, was there acknowledgement that they were required under the loan agreement?
Yes.
Did anyone from City Center offer to raise cash in order to comply with the equity requirement?
Yes.
Who was that?
Richard Plank.
And what did he tell you in that respect?
He told me and the assembled group that he had a lot of liquor licenses that he had held personally, and that he could liquidate those liquor licenses by selling them and raising the capital needed.
Do you know, did he ever do that?
Not to my knowledge.
Did you get consistent answers from Mr. Plank on the equity contributions?
No.
How so?
Some days he said they were made. Other times he said that he would raise the money to make the equity contribution. So it was very inconsistent.
Let's clarify one thing. Is equity in the land the same thing as the equity infusion that was required under the loan agreement?
No.
Why?
The equity infusion that's required under the loan agreement is cash. As I explained before, when a bank does a loan, the initial contribution and payment toward bills comes from the developer or the owner of the property, and then the bank does the funding after that point. So there needs to be a cash injection, and that was what was required by the loan agreement.
Did Fifth Third ever set a deadline by which City Center had to comply with its requests for documentation and so forth?
Not that I recall.
Why wouldn't it do that? Why not?
The entire process that took place was an attempt to bring the loan back into compliance. As I mentioned before, we had to pay subcontractors. They were doing the work, and we felt that they deserved to be paid. And we, at that point, were thinking about stabilizing the project and the loan.
Did you ever personally receive any telephone calls from subcontractors?
Yes.
Were they making any requests?
Yes.
What were they requesting?
They were wondering when they would get paid.
Did you ever have any conversations with Joe Keel concerning funding on residential construction? Do you recall?
I don't recall.
Do you remember a lease with Cold Stone Creamery?
Yes.
Did you have any concerns with that particular lease?
Yes.
Why?
If
Why, I should say, what?
The concern that I had was that the lease was written with, I believe, 1 year's free rent. So they were allowed to occupy the property and stay in the property for 1 year without rent. assuming that they would stay in for the remainder of their term. That was not part of the agreement with the bank, and so yes, that was a concern.
How do we know that's not part of the agreement with the bank? Do you know why they received a year's free rent?
I don't know specifically, no.
Typically, when a tenant receives some months of free rent under a lease, what is it offsetting?
It can offset two things. It could be either an inducement to have somebody come into the property, or it could offset build-out costs or things like that.
Would the offsetting build-out costs for a tenant in the city center violate the construction loan agreement?
Yes.
Why is that?
Because the interior of the property is generally the responsibility of the tenant to build out. There was no provision for that build-out built into the loan agreement or the budget, and so that would have been additional expense that was above and beyond the vertical construction.
Hold that thought. Just turn with me back to the loan agreement, which is Exhibit 4 in the black book. You can do this by yourself. Black book, Exhibit 4.
Okay.
If you would look to would be the second page, Article 5, proceeds. See that at the bottom?
Yes.
Read paragraph 5.1A to yourself. Does that paragraph reference what you just explained to the jury about funding build-out?
Yes.
Did you have the opportunity to look at the general contract at some point in this matter for this project?
I prepared everything, yes.
The best that you can recall as we sit here today, did the construction contract referenced in this article permit tenant build-out?
No.
Would Fifth Third fund tenant build-out costs?
No.
Why?
It wasn't part of the original agreement, and that was something that was related to a single tenant as opposed to the improvement of the entire property. Those are specific build-outs for a specific tenant that would have to probably be altered or torn out if another tenant were to be moved in.
Now, up to this point, we've been talking about economic issues, basically. I want to switch gears and talk about the building aspect of the job. Did you find the nature of the construction compliant with the loan agreement for the most part?
I would say that it was compliant, yes. We had an inspecting engineer.
That is, do you recall ever identifying any issues concerning faulty construction or untimely construction or any other matter related to construction in general?
No.
Do you know whether or not the subcontractors' agreements were initially provided to Third Bank?
I don't know.
At some point, were they provided to you? Do you remember?
I've seen some of them, yes.
Did you request those?
Yes.
Why would you have requested those?
I was getting different answers from the owner of the property regarding many of the issues that were brought up. And so, as the funding process continued, I wanted to verify that the loan was in compliance, and I wanted to look at some of the contracts so we can compare exactly what the subs were supposed to be paid versus what was actually being paid.
Turn with me, if you will, and you can do this individually, to Exhibit 29. It's in the black book, 29, near the back. you there? And just look at the first page, the lower left-hand corner. Where there's a notary seal. Do you see that?
Yes.
What's it say? Read to the jury what it says about that notary seal.
Statement reflects the total cost of construction subscribed and sworn to before me this 9th day of February 2006.
What's that mean? Subscribed and sworn to.
That means that they are saying that this is the true facts of what was submitted to them. And everything in here should be a representation of a contract or some type of bid that's actually been finalized relative to the building.
Are you now, or have you ever been a notary?
No.
You haven't been?
No.
Did there come a point in time when payment of profit to the general contractor became an issue?
Yes.
How so? Do you remember?
The loan agreement specifically precluded the payment of profit to the contractor until all of the obligations of the construction were met and the building was stabilized.
What about overhead? Was overhead permitted?
Some overhead was probably permitted, yeah.
To your knowledge, did Fifth Third declare a default for failing to comply with any provision in May of 2006?
Did they?
Yeah. To your
No.
knowledge? To your knowledge, did Fifth Third Bank ever declare a default for failure to comply with the loan agreement or any other of the documents pertaining to the loan in July of 2006?
No.
If I were to ask you the same question about August of 2006, what would your answer be?
No.
Do you know Fifth Third Bank declared a default in September of 2006?
No.
Now, why didn't the bank declare a default at that point?
I think I mentioned before, our bank hates to take back property. That is the last thing that we want to do when we make a loan to anyone. So what we were doing during this process was attempting to stabilize the project so that it could be successful. We were trying to get the loan back into compliance by looking at the documents that were supposed to be in the loan file. And we wanted to pay the subcontractors because the payment of the subcontractors, the non-payment of the subcontractors could adversely affect the property. They could file construction liens, and that was something that we didn't want to see.
During the entire time that you administered this, I shouldn't say administered, I should say served as relationship manager on this particular file, did you ever receive the financial documents that you were requesting?
No.
Now, do you recall the last draw number 7 in July of 2006? Do you generally remember that being the last draw?
I remember that is the last draw.
Look at Exhibit 32 in your black book. Let me know after you've had an opportunity to look at those various pages. Have you? Okay. Are you familiar with Exhibit 32?
Yes.
And is this something that you reviewed at one point in time?
Yes.
Now, the first page, which is base stamped number 5, just generally, what is this?
This is a sworn construction statement, and the construction statement attests to all of the subcontractor arrangements that are required to build the building that was loaned against. What the statement also does is state how much has been paid to date to each of the contractors and what the remaining balance is due. There's typically also retainage in the statement, which means that there is an amount held back from every contract in case there's something missing at the end or repairs that need to be done to complete the job to normal standards.
Turn back 2 pages, and that is Exhibit 32, and there's a document in the stamp in the lower right-hand corner, Exhibit 30. Can you see that?
Yes.
Are you familiar with that document?
Yes.
Does this also pertain to draw number 7?
Yes.
Why is there a difference, if you know, between the first page of Exhibit 32 and the third page of Exhibit 32?
Well, it could be for lower number of buildings.
How many buildings?
Well, there were only 2 buildings that were built at the time and 2 foundations.
So, for instance, if we look at, for instance, masonry, Hawk LLC on that page 3, the total contract is how much?
On page 3?
Yes.
$1 million.
And if we go back to the first page, the total contract is how much?
$2 million.
50%, correct? Do you know the total masonry contract, how many buildings that was for?
Well, that should have been for all of the buildings.
Meaning how many? 4? Or
That would have been for all 6 of the buildings that were planned.
if the actual contract shows that it was $3 million for 6 buildings, how much would that be for 2?
For 6 buildings, that would be $1 million.
The same as page 3 on Exhibit 32?
Yes.
If I went down to Lazaro on the first page of Exhibit 32, see that? Windows, doors, interior?
Yes.
What's the total contract price there?
$100,000,
And what is it on the third page of Exhibit 32?
$50,000.
Exactly 50%, is that true?
Yes.
Do you see any correlation between these 2 documents?
It appears that therefore a lower amount of buildings.
Did you prepare this document? The third page of Exhibit 32?
No.
Did you review it before the draw? For the
Yes.
7th draw? Did you approve the third page of Exhibit 32 before the draw?
Yes.
And after you approved it, where did you send it?
All of our draws are sent to the funding desk in Rolling Meadows, and there they're reviewed again.
Do you know who reviewed it in this particular case?
I don't know specifically, assuming Cindy Jensen.
But in the normal process, after they review it, where does it go?
It goes to the title company for funding.
Why did you approve or recommend for approval draw number 7?
The objective with the loan relationship was always to pay the subcontractors and to get the loan back into compliance, and also to stabilize the project. We felt that it would not help the loan situation by stopping the funding. We were hoping that we could get an agreement in place by getting the documentation that we needed, and it could go forward.
let me have you and you alone turn to Exhibit 89 in the red book. And it's folded over, so. Are you familiar with that document?
Yes,
And that's something you've seen before?
yes,
And is that something you'd see in the normal course of business at Fifth Third Bank?
yes.
With the introduction of Exhibit 89? 89?
No objection.
89 is submitted.
No. Once we get there. Maybe you can fold that over. We can take a look at this. There are a lot of numbers in the lower right-hand corner of this page. It looks like an adding machine table. Do you see that?
Yes.
Could you explain to the jury what all these numbers are?
Well, typically that would be a reconciliation of the loan and the activity that had occurred prior to this funding request. So you would see what the initial draw was on there, you would see what the prior draws, and then you would subtract those total from the approved loan amount. The bottom line generally represents what is still available to draw on the loan.
So, in this case, if we look at the bottom line of Exhibit 89, how much money was left for City Center to draw against that was left in the construction loan?
$3,300,000 approximately.
Had they remained compliant, would those funds have been available to them for the construction of the remainder of phase of this project of 4 buildings?
Yes, absolutely.
Does, while we're talking about that, does Fifth Third, in its review of the sworn construction statements, ever recommend any modifications or changes to a sworn construction statement?
We do look at the construction statements to make sure that they foot to a contract.
That is, if the construction statement that's submitted fails to comply in some manner with the contract, what happens?
Then we can request a revision or at least ask why that was done and ask for documentation as to why a change should be made.
And if a change is required, what do you do?
We ask for documentation and we speak to the owner and ask them, could you provide us the documentation on why this has changed? Or we can tell them that this is not something that's fundable under your loan agreement. It needs to be changed.
Does that happen by email, by phone, in person?
It could happen by phone, by email, in person.
Who initiates a drawdown on a construction loan? Who initiates that?
The borrower.
How?
They receive invoices from their subcontractors and they prepare the sworn construction statement and then they send it to the bank for funding.
Does the bank have any idea of even knowing when a draw request is coming?
No.
Does the bank even have any idea what the total contract amounts are. At the first draw, let's say. Would they even know that? At the first draw request.
The first draw request,
Yes.
you're asking about what the subcontractor contracts be
Right.
reviewed?
Right.
They could or they couldn't. I would say generally they probably would be.
And let me refer you to make sure it's admitted. Let me have you only look at Exhibit 61 in the Red Book. Are you there?
Yes.
Okay. You recognize this document?
Yes.
Did you prepare it?
Yes.
Let's move to the introduction of Exhibit 61.
No objection.
61 is admitted.
Could you tell me the date of that email?
August 30th, 2006.
And who's it to?
To Joe Keogh.
What was the purpose of that email?
To obtain the documentation that we've been requesting since May.
So, during the month of June, after your May 16th request, did you receive this documentation?
No.
In the month of July, after requesting this information, did you get it?
No.
And now we're into August, and the whole month of August, you're sending this email. Is that true?
That's correct.
Read that first line of the second paragraph yourself. You say this information is not important, it's very important. Why is that so?
Because the loan was still out of compliance, and we were really attempting to stabilize the project so it could go forward. We were getting phone calls from subcontractors regarding payments, and we were still at the same place where we were 4 months ago, with no financial statements, no leases, no evidence of equity, and a lot of conflicting information.
The next sentence in that paragraph reads, the project is behind schedule and over budget. See that?
Yes.
What do you mean by it is behind schedule?
This is an economic measure for the bank. It doesn't really relate to the activity of the construction. When a project is behind schedule for the bank, it means that all of the compliance actions have not been taken. So if the leasing is behind, then that project is behind schedule because of the fact that it will take longer for that building than originally expected to start generating revenue. So that was my reference in being behind schedule.
And what about over budget?
Over budget referred to the fact that the longer that the building was not able to generate revenue on its own, there would be additional funding required to pay the interest on the loan, and it also referenced some of the build-up that had taken place. None of those things were taken care of in terms of any documentation.
Did you, as the relationship manager, have the authority to withhold any draw request?
No.
Who did? You know?
The funding desk.
Up until draw number 7, up and through draw number 7, did you ever make a recommendation to anyone to withhold a loan, a draw?
No.
Move to the introduction of Exhibit 62.
Sure, but again.
61 or 62?
62.
No objection.
62 is admitted.
Turn with me, if you will, to Exhibit 62. Did you author this letter?
Yes.
And it's dated what date?
September 6, 2006.
And this would be after your August 30 email, correct? Did you author this?
Yes.
What was the purpose of sending this letter?
The purpose of sending the letter was to inform the owner of the property, Mr. Plank, that because of the non-compliance, we had to transfer the property to our Special Assets Division, who would continue to work with him to bring the loan back into compliance.
The first paragraph reads, I attempted to call you directly today at your office in Crown Point, but you were not available. Was this letter preceded by a telephone call?
It appears that was.
Do you recall receiving a return call?
I don't recall.
Okay. Why wasn't this loan transferred sooner to this other department? The Special Assets team.
We attempted to work through the loan issues with the borrower. The loan was made in good faith by the bank, and I'm sure by the borrower, and because of that, we wanted to work with the borrower to get the loan back into compliance so that construction could finish and that the property could become stabilized. We also, again, had to pay the subcontractors. We wanted to keep the project moving for that reason. So the compliance with the loan terms were very important.
Let's move to the introduction of Exhibit 90.
I think you know that foundation for that one, so I would suggest in that basis.
Your Honor, it's been authenticated by the pretrial order. Foundation need not be laid. The only objection is would be relevancy or materiality.
Who authored it?
Your Honor, it's been authenticated as a business record. Don't have to lay a foundation.
Or do we even know if she's seen it before?
Yeah, I know. Yeah.
Why don't you-
Well, we have a sidebar.
Yeah.